Morning, Your Honor.
Hey, good morning. Everybody's here, ready to go. Mr. Schroep, I guess you're the appellant, so you go first.
I do, yes, Your Honor.
All right, proceed.
Good morning to the court. I would like to reserve 5 minutes for rebuttal if I could. I
Yes,
actually
sir.
anticipate that my presentation will be pretty short,
Okay.
so there'll probably be plenty of time. May it please the court, my name is Charles Schroep, and I represent the appellant in this matter, Heatsink LLC. As the court is aware, this case involves an insurance dispute concerning the theft provision of an auto policy issued in Michigan. Mr. Boss, the principal owner of Heatsink, decided to retire to Florida. He brought Heatsink's insured truck with him and made an effort to sell it privately and through consignment. After one failed effort at consignment at another dealer, Mr. Boss made contact with an auto dealership named Exotic Motor Cars, run by a gentleman named Wasim Nasir. This dealership, which Mr. Boss described as extremely aggressive and badgering him to consign Heatsink's truck, ultimately convinced Mr. Boss to deliver the truck for consignment at Exotic Motor Cars. This turned out to be a grievous mistake, as Exotic Motor Cars had a few months prior effectively gone rogue, using forgery and fraud to steal a large number of cars and make unlawful and unauthorized sales for its own benefit.
Well, was there any dispute that Michigan law required or interpreted the word theft to provide coverage if there's a wrongful taking, asportation with intent to deprive the owner of property permanently? Was there a definition imported from Michigan law for theft?
I believe the term theft is undefined in the policy. Michigan law would govern what the, I guess the meaning of the.
Okay. Well, I mean, it looks like they cited a case from Michigan that says exactly what I just asked.
I'm sorry?
You're agreeing that Michigan law applies, and Michigan law interpreting the word theft in a coverage dispute is controlling.
I would agree with that. I think that the answer is a little bit more nuanced. For example, one of the things that we cite in our brief is the theft by conversion statute, which specifically, mentions fraud, embezzlement, et cetera, et cetera. So I would not agree that, that this old version of common law applies. And as a matter of fact, Your Honor, one of the things is I think that, there's some conflict between one of the cases that we mentioned is the Turley case from the United States Supreme Court, which kind of explains the evolution of the law, whereas there were these common law precepts and the law evolved to pretty much recognize any version of theft, including embezzlement, fraud, deception, et cetera. Does that answer your question?
Yes, it does. Thank you.
So under the agreement, remind me, what would have happened if if Heatsink had decided, the car hasn't sold, I'm just going to take it back. Can I get my title back?
Absolutely, Your Honor. That's exactly what happened. Is that the agreement that was signed had no restriction on his ability to take back possession of the car. He could have literally gone to the lot, taken it back. Now the title was taken under false pretenses. In other words, what they said is, we have a prospective buyer. The bank needs to examine the original title. However, what happened is that there was no bank loan at all involved in the ultimate purchase. The person made most of the payment in cash, a vast majority, and the rest was financed via credit card. So there was no need for an auto loan that the bank would examine the title. It was a lie. It was a fraud. And what it was done for is so that they would have the original title for a cash buyer, who would otherwise would have been reluctant, to put down money if they didn't have the title available. And obviously the titles have all kinds of security features.
I mean, can you break this down to a simple occurrence? Did the dealership, so to speak, just keep the money and fail to pay it over?
I would disagree with that because Mr. Boss specifically testified that the sale was not authorized, and he did not sign the title because he would not do that until such time as payment was delivered.
So they had the title, whether they forged his name or not, they kept the money.
That's correct. They did keep the money.
Okay.
However, and that's one of the key distinctions. One of the arguments that State Auto relied upon heavily below was that what was stolen was the money, not the car. And our point is that, when the title is taken under false pretenses, apparently forged, there's no, because forgery was shown, if you read the police statements that were provided, that was what this was. This was a case involving up to 80 victims, is my understanding. And what happened is that they were forging title documents to accomplish sales. And, so that if that answers your question. As noted in the brief, State Auto's position below relied upon a number of factual contentions that simply cannot be supported in this case. Specifically, State Auto's assertions that the transaction proceeded, quote, in accordance with the parties' consignment agreement, unquote, and that Heatsink had, quote, voluntarily relinquished title, unquote, do not correspond with any known versions of the facts. What actually occurred is that Exotic Motorcars obtained the original title under false pretenses, telling Mr. Boss that it was needed for examination by a bank considering financing for a prospective purchaser. This original title, which was not signed by Mr. Boss, was then apparently used to consummate an unauthorized sale of the vehicle, likely via forgery of the title documents, as had happened to other victims of Exotic Motorcars. It should be noted that the police report pertaining to the theft of Heatsink's truck indicates that the transaction was ultimately completed mostly through cash and a smaller amount via credit card. There is thus no reason to believe that there was any need for examination of the title by a financing bank, as Exotic Motorcars fraudulently contended. As noted in the brief, State Auto's arguments below focused upon the proposition that Heatsink's money was stolen, not its truck. This position, however, was made untenable by the fact the sale of the truck was not authorized, as was expressly testified to by Mr. Boss. The actual dispossession of title from Heatsink in this case was conducted through an unauthorized sale and likely involved the forgery I mentioned earlier. Thus,
now, did the consignment agreement afford the, I guess, is it the consignor?
No, Your Honor. There is
ability to approve or disapprove of any individual sale.
It allowed them to reach an agreement as to price, but what's required is a power of attorney, and that was not present in the consignment agreement, and nor was it intended. In other words, Mr. Boss did not sign the title for the reason that
refuse any offer.
My understanding is that there was a provision that there was a blank. They did not have the original contract. Exotic, there was no record of the sales in its records. The police did a search warrant. So in other words, we don't have the original. Mr. Boss testified that there was a number put in the blanks as far as the net amount that he would receive, and he did not remember the exact amount, but I think it was $17,000 or $18,000. I think that there would be an agreement for sale there, but there would not be, there's no power of attorney or any. They had a blank for like net proceeds, but I don't think that the sale price would have even hit that. So the answer is no. There's no agreement, and it certainly was not a power of attorney.
So does the whole thing turn on what the definition of theft consists of?
I'm sorry, Your Honor, I couldn't hear you.
Doesn't the whole case turn on the definition of theft, which is not defined in the policy?
That's correct, Your Honor. In other words,
give me your best argument as to why what happened constitutes a theft.
Well, Your Honor, I think that the analysis under Michigan law takes two branches. Number one, as we explained in the brief, there's if there's a fraudulent intent at the outset, State Auto has acknowledged that even under those circumstances, that there would be coverage because they talk about it supplying the necessary element of trespass. And then there's the theft by conversion statute, which includes embezzlement and fraud. So if, for example, we found that if we wanted to argue, as State Auto does, that the intent to defraud came after the vehicle was relinquished, that statute would be applicable, and that includes fraud, embezzlement, et cetera, et cetera. So there would be clearly theft by conversion under statute under Michigan law if that were the case. So I think that either way, either branch results in coverage. if you see what I'm saying. Does that answer your question, Judge Black?
Yes, thank you. Yes, it does.
As was noted in the brief, State Auto's arguments below focused on the proposition that Heatsink's money was stolen, not its truck. This position, however, was made untenable. I believe I already read that. Thus, it is quite evident that Heatsink's title to its truck was stolen, not the proceeds from the sale. It is also of no moment that Heatsink adds exotic motor cars to forward proceeds of the unauthorized sale, as this was the only sensible way for the insured to mitigate damages from the unauthorized sale. Also, as we noted in the brief, State Auto shifted its argument somewhat on appeal, arguing that Michigan law provides an idiosyncratically narrow definition of theft. The cases it cites, however, don't really provide any support for that proposition. As was explained by Turley, theft is generally considered to be broader than common law larceny. The High Court further observed that by 1919, the law of most states against local theft had developed so as to include not only common law larceny, but embezzlement, false pretenses, larceny by trick, and other types of wrongful taking. State Auto has woefully failed to demonstrate that Michigan does not follow this widely accepted understanding of the term theft. Indeed, MCL 750.362, Michigan's theft by conversion statute, shows that Michigan does indeed follow this majority understanding of the term theft by explicitly including both fraud and embezzlement. In this case, there has been some dispute as to whether the facts support fraudulent intent by exotic motor cars at the outset of the transaction or sometime after delivery of the vehicle to exotic motor cars. Well, Heatsink believes that the evidence supports a fraudulent intent by exotic motor cars at the outset, with the purported consignment agreement just being an artifice to obtain Heatsink's truck. Coverage exists in either event. First, as to the intent to defraud by exotic motor cars that came before relinquishment of the vehicle, even State Auto acknowledges that there would be coverage. Specifically, State Auto acknowledges on page 20 of its brief that, quote, Michigan courts have held that if a defendant had a felonious intent at the time of acquiring possession of property and subsequently converted the property, the initial fraud would supply the element of trespass, unquote. To negate this obvious problem, State Auto argues that Heatsink presented no evidence of any pre-relinquishment intent to defraud. This position is simply bizarre, however, in that exotic motor cars fraudulent conduct was documented as having begun a few months before the relinquishment, and it ultimately apparently encompassed as many as 80 victims. State Auto also argues that this argument was not preserved, a contention that is absurd in that Heatsink's trial counsel deliberately focused on the repetitive nature of the frauds for the very purpose of establishing fraud at the outset. I will turn next to theft by conversion that would apply if the intent to steal arose after relinquishment of the truck. As mentioned earlier, MCL 750.362, Michigan's theft by conversion statute, does State Auto no favors, explicitly including fraud and embezzlement, thus entirely destroying State Auto's position. State also makes an additional argument regarding this issue that relies upon a legal doctrine known as the economic loss rule that holds that a civil action may not generally be filed for conversion if the transaction is subject to a contract. However, as State Auto itself acknowledges, what constitutes theft for insurance purposes in Michigan law is driven by criminal, not civil law. The economic loss doctrine has no application to criminal matters, as is shown by the case of People v. Mason, and cited in the reply brief and presumably other authorities in Michigan law. As such, even in the instance that criminal intent arose after relinquishment, there would be coverage as well. It should be noted that Florida law has a role to play in this case. Specifically, Florida courts have held that when the law of a foreign jurisdiction does not answer a question, then the answer to that question will be deemed to be the same as that provided by Florida law. Here, Florida law provides the ambiguous answer through State Farm versus Pridgeon that there would be coverage here. As such, any reliance on non-Michigan, non-Florida authority was inappropriate. To the extent Michigan law did not answer the question, Florida law would apply. For the reasons—
Did anyone get arrested, Mr. Schroep?
What's that?
Did anyone get arrested for grand theft auto?
Your Honor, I believe that Mr. Nasser fled the country.
So the answer is,
I believe that
there's
he
no
was
warrant outstanding, he fled the country, or there's a warrant for grand theft auto outstanding?
I don't know the status of the warrant. It's not on the record. The police
Okay, well, you
report.
don't have to answer that then. We don't know what it's for either, right?
There is a police report stating that he committed grand theft auto, so I would presume that there's a warrant out for his arrest. My understanding outside of the record is that he has fled the jurisdiction.
Okay, gotcha.
Um,
You're almost you're just past your 5 minutes. You want to save that for rebuttal?
I'd finish up here, Your Honor, and then go from there. For the reasons presented here in the briefs, Heatsink urges the court to reverse the summary judgment granted below. Moreover, given that no response was filed to Heatsink's attorney fee motion and it is thus unopposed, Heatsink would request a provisional order for attorney's fees as well.
All right, you got 4.5 left. You're going to save the 4.5 for rebuttal?
Yes, Your Honor.
We'll switch over to your opponent.
Good morning, Your Honor.
Ms. Raham, you can proceed.
Thank you for your time. I'll be brief. I'll start with the proposition that the lower court at the summary judgment level ruled that there was no theft here, as that term is defined by the policy, on the basis that Michigan law applies. And the parties don't dispute here that Michigan law applies. So the issue just becomes whether there was a theft of a covered auto.
Is there a warrant out for grand theft auto?
My understanding is the same as opposing counsel's, that the owner of exotic motor cars may have fled the country and that there were several other consignments.
I mean, is that a red herring? That's not a legal determination. That's the officer's opinion or request to justify the warrant, but it doesn't compare the policy to reality. You can still have two different tracks here for two different situations. One could be civil, one could be criminal, correct?
Yes, and so at the outset, since this is a question of whether coverage exists, the burden would be on the insured to establish that coverage. And here it's our position that they had not only have they not established
the burden, but the burden's on the summary judgment was entered in favor of auto, right? Yeah, so the burden is to show there's no dispute of fact on whether there was coverage.
I mean,
so on that, let me read something from your brief on page 46. There's been a couple different ways larceny by trick is described in the briefing, but yours is pertinent to my question. The crime of larceny by trick consists of the following elements: criminal taking of property by means of fraudulent contrivances rather than trespass. So that eliminates your argument that there has to be an actual taking against the will of the victim. And then when the true owner has no intention of giving ownership, but only intends to give up possession. I don't know, don't have in front of me the consignment agreement itself right now, but my general understanding of a consignment is that you don't intend to give ownership to the entity that is consigning your vehicle. You tend to give ownership to the ultimate purchaser. So didn't they fraudulently take title and then themselves sell to a purchaser?
Your Honor, the evidence does not establish that that's what happened. Actually, what is established based on Mr. Boss's testimony, who's the owner of Heatsink, is that he was called by the dealership while he was out of town and notified of a prospective sale and the amount of that sale. And he was asked to provide a copy of the original title in order to facilitate the financing of that sale, to which he consented. He instructed his mother to give the original title to the dealership. And it was his understanding that he would then return from his trip, sign the original title, and obtain the money. And so when he returned, he came and he demanded that he be paid the net sale proceeds pursuant to the consignment agreement that he believed he was owed for the sale of the vehicle. He returned 3 times to the dealership to make that demand. When those attempts proved to be futile, he filed a police report, which my opposing counsel relies very heavily on. And in that police report, he concedes that he had been advised of the sale all over the phone and that he consented to that sale. He also advised that he agreed to the amount and that the buyer reportedly negotiated that price, and that he contacted the dealership but was unsuccessful in obtaining the proceeds from the sale of the truck. So the question becomes, did he authorize the sale? And I think that there is no evidence to suggest that he didn't authorize the sale, notwithstanding that he never signed the original title. And again, because we're relying on Michigan law here, we turn back to what the definition of theft is. And there is no definition. So we look to the plain and ordinary meaning of the word. And both counsel and myself have cited repeatedly in the summary judgment level all of the different terms, all of the different definitions of theft, which all include wrongful or unlawful taking of property in the first instance. And there is no wrongful or unlawful taking here, as everybody has conceded, because this gentleman came to the dealership, turned over the keys, paid $100 for them to take possession of the vehicle, and signed a consignment agreement that then authorized the dealership, upon acceptance of an offer, to then facilitate and complete the sale, which is exactly what they did. And the evidence, the police reports that opposing counsel relies on, also established that actually no forgery of the title may have even happened, because they contacted the buyer, the third-party purchaser, and he was never able to obtain the title. So even though he did pay for the vehicle and take possession and receive a temporary tag, he never actually took title to the vehicle before.
Wait a minute. So in other words, they stole a vehicle from the seller and the buyer?
Well, I would suggest that they didn't steal it.
I mean, yeah, the seller had the physical possession, but so in other words, does the exotic motor car, for all we know, still has the title?
For all we know, correct.
Yeah. So in other words, they took the title under false pretenses, saying that they needed it for the buyer's financing purposes. And then they didn't even give the title to the buyer.
Well, we don't know if they took it under false pretenses, because we don't know if it's the case that the buyer was unable to obtain financing.
So why is summary judgment appropriate if we don't know? Doesn't that sound like a dispute of fact?
Because it's the question is whether there's a theft, right? And so, is there an unlawful taking? The answer is no. And so what opposing counsel has tried to do.
Under theft by trick, or whatever, larceny by, or theft by deception under Florida, I think is what it used to be called. The taking is by getting it under false pretenses. So you don't have to have that's eliminated. I gave you the truck and I gave you the title to the truck, but I gave it to you under false pretenses. But isn't that a question of fact of whether the pretenses were false, whether they ever intended to actually sell it to a third party and give the title and the truck to the third party, and then take the proceeds and after skimming off the top for their services, give the proceeds to the seller?
So I think that it's important to separate the two transactions. The first is the possession and the sale of the vehicle itself, notwithstanding the title. I believe that there is no evidence, and nobody has cited any evidence to show that the sale itself, the simple, here's the amount that we're selling your car for, here's the buyer, that was authorized. Indeed, the police report itself says that Mr. Boss authorized the sale for the amount that was stated. Now the question just becomes, did the dealership obtain the title under false pretenses? And the answer is, quite honestly, it doesn't seem to be the case at all, because the dealership did obtain the title for the purpose of facilitating the sale. The sale was in fact consummated. And
was it necessary, at that time, to obtain the title prior to the actual transfer of the vehicle?
If in fact the prospective buyer was attempting to obtain financing, I would venture to guess that yes, you would need.
Isn't there a question of fact of whether that he was, and whether the financing was the type that required the title to be showed to the lender?
I don't think so, because the question of fact is really only whether there was a wrongful taking, or whether there was whether the dealership. Isn't
my question a question of fact that supports whether the ultimate conclusion of whether there's a wrongful taking?
I don't believe that's accurate statement of what the question of fact is, Your Honor. I think that the question of fact is, and has always been, A, was there a wrongful taking? And the answer is simply no. And then the question becomes, well, is there another means by which we can supplant the wrongful taking and establish theft? And I don't think that that's been established by the evidence here, or by any of the documents that counsel relies on. And if I could just run through the explanation of why I think that's the case, I think it may ultimately make clear my position. Here, I think that there's, again, like I said, Mr. Boss conceded that he voluntarily turned over the keys, paid the money for the dealer to take possession of the vehicle, signed the consignment agreement. The consignment agreement explicitly says that if you accept a prospective offer, the dealership is now authorized to consummate that sale. So no unlawful taking. To supplant unlawful taking, Heatsink argues that the dealer initially entered into that consignment agreement with the intent to defraud Mr. Boss, and that they never actually intended to honor the terms of the agreement, is I think the quote. Heatsink can't read minds, and they can't decipher the fictional intent of a corporate entity.
Isn't that what a jury does? Decide whether the Exotic Motors intended to defraud, which is I see here in this People versus Luth, the Michigan Appellate Court. Intent to defraud, and then the accuser relied on the false pretense, and then they lost the property, and the property was obtained by the defendant thereby.
The intent to defraud if we already concede that the sale was authorized by the owner of the vehicle.
So wait a minute. So the theft by deception isn't that the scenario in which there was a voluntary, if the physical relinquishment of the property is usually voluntary based on some representation. So I think you're skipping over a part, yeah, or you're presuming a conclusion merely based on the fact that the seller willingly relinquished the property. But isn't that always going to be the case in theft by deception or larceny by false pretense or larceny by trick?
Correct, but he also consented to the sale, which is the second prong. He consented to the sale when he was notified.
But if the Exotic Motors never intended to actually uphold the deal and provide him the money for the vehicle, this is just a sale based on with an intermediary. So if a guy on a street corner with a trench coat sells watches, and he says, here's the watch, the watch is $50, and the person, and he willingly gives the watch, places it into the hand of the pedestrian who, expresses interest in giving money for the watch, and the guy runs off, then that's theft by deception.
Yes, or the other.
If there's an intermediary, why does that matter? If the intermediary is the one who essentially runs off with the car, gives it to a third party, pockets the money, why is that not theft by deception?
Because as the case law makes clear, that's theft, but it's not theft of the item itself. It's the theft of the proceeds, and that's not covered under the policy. So all of the case law that Prigden is, I think, the case almost exclusively cited by opposing counsel for that very proposition, that if you run away with the item, that's the theft of the item, even though you agreed to sell it and otherwise the sale was commissioned and authorized as it was. The court in Prigden says it stands for that proposition, but it relies almost exclusively on a Florida anti-fencing statute, which defines theft broadly to encompass things like embezzlement, concealment, fraud and inducement, things like that. The case before Prigden, which is another Florida case, and it preceded the anti-fencing statute, is the case of Paris, which is the case that we cite in our briefs. And that case that stands for the proposition that I'm telling you now, which is that if you knowingly and voluntarily turn over possession of the vehicle, the keys and the certificate of title for the purpose of facilitating and completing a sale that you have authorized in compliance with your agreement, then in effect, even if you don't end up getting the benefit of the bargain, which is the money that you were supposed to get, then they've stolen the money. They haven't stolen the vehicle, because the vehicle's sale itself was authorized. And that's exactly what happened here. And Paris is still good law in other states that, like Michigan, do not have an anti-fencing statute. And the cases that we've cited for that proposition include Stone, which is also a case where it involved a consignment of a vehicle, and it involved the absconsion of the seller, or the middleman, I'll say, with the proceeds. And the court said that, okay, well, you turned over the car for the purpose of this consignment dealer selling the car. They sold the car, and they never gave you the money. And in Stone, I believe also as well, there was an issue that title was not actually given, but they said that you agreed to sell the car, and they sold your car, and then you asked for, they never paid you the money. And so the theft there is the theft of the funds. It's not the theft of the auto itself. And that's the key distinction that we're making here. We're not arguing that there's no theft here. We're arguing that there's no theft of the vehicle based on.
Well, you do kind of argue that too, right? You say, well, this is just a contractual dispute. This is just a breach of contract. But you also have an argument. trying to separate your arguments. Your argument also is that there is a theft, but it's a theft of money, not of a car.
The argument in the alternative is correct. If there is a theft, it's not a theft of the vehicle itself. And that's the proposition that we stand for today. And the cases that we've cited support that proposition. So I think it's important to also note that Heatsink argues that it was unlawfully dispossessed of this vehicle here because it didn't sign the title, right? Even though it concedes that it voluntarily otherwise gave possession and authorized the sale of the vehicle. It just says that, well, we've supplanted unlawful dispossession of the vehicle with the fact that he didn't sign the title when he voluntarily gave over the original copy to the dealer to facilitate a sale that he was otherwise notified of and consented to. There's no evidence to show that the title was forged here, as I said previously, in connection with the sale, or that it was fraudulently conveyed to the buyer. In fact, the evidence that the appellant relies on shows that the opposite is true. The buyer paid in cash and credit and was given the vehicle and a temporary tag, but was never actually given the title. And there's Florida statutes that stand for the proposition, I believe it's Florida Statute 672403, that says that, actually, I apologize. It's 31922 that says that a person acquiring a motor vehicle from an owner, whether or not the licensed dealer, does not acquire a marketable title to the vehicle. But the case law that interprets that says that, well, even if you don't acquire a marketable title because you don't get the title itself or for whatever reason, you do acquire some interest in the title itself. So even there exists a situation where you can sell a vehicle as a dealer and then maybe not comply with the requirements of the sale, which necessarily require that you hand over the title, but that doesn't mean that the sale itself, separate and apart from the handing over of a valid title, was itself unauthorized and constituted a theft in the first place. And Heatsink's new argument here on appeal is that a theft occurred in the absence of that unlawful taking, and they rely on the doctrines of obtaining property by false pretense and larceny by trick, but these arguments weren't raised by Heatsink in the summary judgment level. In fact, they concede as much, and they say that these are actually logical extensions of the facts that were presented at summary judgment, but they didn't argue these legal theories. And they cite no case law for the support of that exception to the longstanding principle that if you don't raise an objection to a summary judgment for a legal argument in opposition to a summary judgment, that you waive that argument on appeal. So for this reason alone, we think that that's enough for the court to affirm summary judgment without even looking into the further discourse. But even disregarding the impropriety of these arguments on appeal, I still think that they don't change the outcome, that the theft of the vehicle did not take place here. And Heatsink relies on People versus Mason to show that larceny by conversion occurs when a person obtains property for a specific purpose, as you said, and then uses that property for another purpose. The critical distinction here is that the dealer obtained the vehicle for the purpose of selling it to a third party, and that the vehicle was ultimately sold in accordance with that purpose for which it was obtained. So People versus Mason doesn't apply because the consignment agreement itself here authorizes the dealer to sell that vehicle once the owner accepts the offer. And the owner accepted the offer according to what his statement.
I know there wasn't, but if there was proof that there was a fraudulent intent from the very start to acquire this vehicle, that it was never intended, that Exotic never intended to do what, to follow the law, sell the vehicle, turn over the proceeds to the owner, would that defeat your argument if there was proof of a fraudulent intent from at the beginning?
No, Your Honor, because there's cases that stand for the proposition that it doesn't matter if you prove that the intent of the dealer was fraudulent at the inception, so long as, here, I'll pull up the case so we can read it together.
So even if it was taken by fraud and that was part of the record, it would still not constitute a theft.
Yes, and that case that stands for that proposition, okay, it's actually Stone versus Nationwide, and that case says that
the California case.
Yes, it's the California case, and it relies on Paris, which is a Florida case that preceded the Florida Anti-Fencing Act, and so it would seem to be more on point with Michigan than Prigden, because Prigden was based on Florida's Anti-Fencing Act, which Michigan does not have.
Okay, thank you.
You have
Yes.
about a minute left.
Thank you. So I'll wrap up very quickly. Heatsink argues that this court should disregard the holdings of the sister states, which, like Michigan, do not define theft by statute, and should instead apply Florida law as it was pronounced in Prigden. Prigden is at odds with Michigan law because it explicitly relies on what it calls a broad definition of theft, which was given to that term by the Florida Anti-Fencing Act. That act defines theft as knowingly obtaining or using, endeavoring to obtain or use property of another with intent to deprive the person. This is markedly different and vastly broader than the common and ordinary definition of the term theft, which, as I previously discussed, requires an unlawful taking in the first instance. In fact, another Florida case that addressed the same issue as Prigden, which was Paris, and I mentioned that briefly, Paris preceded Florida's Anti-Fencing Act, and in that case, the plaintiff left the car with the salesman to sell it. The salesman sold the car and deposited the money into his personal account and gave a check to the plaintiff. The check was returned for insufficient funds. The salesman then absconded. Plaintiff never got the money, and they sought to cut coverage from their insurer for the theft of the car. The Paris court concluded that the salesman may have absconded with the proceeds of the sale by not depositing the money in the plaintiff's account, but it didn't amount to a theft of the car under the policy. For this reason, State Auto has identified several cases from sister states that, like Michigan, also do not have a statutory definition of theft. Those cases rely on Prigden and reach the
Ms.
same.
Frame, your time is up. Did you want to take 5 seconds to say something
Yes,
else?
I would say that the alleged fraudulent intent of the dealer at the time it takes possession supplants the. I'm sorry. I apologize. The cases that rely on Prigden reach the same conclusion that we do here, and they reject the arguments that Heatsink makes here, which is that fraudulent intent of the dealer at the time it took possession supplants unlawful taking, that is the prerequisite of theft, and that the sale is otherwise compliant with the terms of a consignment is unauthorized merely because it is.
All right, you now I'm going to cut you off since it seems like you're reading from something. So that's the end of your time. Thank you. We're going to switch to Mr. Schroep. Since I gave your opponent extra time, I'll bump you back to 5 minutes, okay?
Thank you, Your Honor. The first thing I'd like to mention is they talk about no statutory definition of theft. Well, I gave the larceny by conversion statute. So it certainly seems that, as mentioned, Turley says that theft is actually broader than larceny, and larceny is inclusive of embezzlement and all the other things they're talking about. So I'm a little bit, surprised by that. And also, Judge Atkinson made a number of salient observations about disputes of fact. And I remind the court that this is under the former summary judgment standard, that's how this case was decided. And this is a de novo review. Also, the testimony of the facts was quite a bit different than what is suggested. I would say that, Mr. Boss' testimony was that he did not remember the exact financial amount discussions, but he explicitly said that that the sale was unauthorized. And, he testified that he did not believe the amount that had been suggested for the sale would have been adequate and that he would have accepted it, although the police report does contain some conflicting information on that in the interest of full disclosure to the court. As one of the things that counsel observed was that the police report that said that no title was delivered. I think it's important that the court understand that the time frame for all these crimes appears to have been quite compressed. That this sale transaction allegedly occurred on August 7th, I believe 2018, and this gentleman was arrested on August 10th, 2018, for a fraud that had, I guess, begun in May of that year. So in other words, basically this automobile dealership went rogue, and was not really, was completing consignment sale or consignment agreements for its own benefit and not for the benefit of the people that were, selling vehicles. That's pretty clear. And there's certainly a dispute of fact about that. As far as, her discussion of Prigden, one case that I would refer the court to is Park. One of the things that the Paris case, I believe it was the Paris case, distinguished Park and said in that case that the person intended to retain the title, even though it was signed, until that person was paid. This case is very analogous in that there was no intent to convey title by, allowing the exotic motor cars in this alleged financing institution, which apparently didn't exist, to, examine the title. And I really think that what happened here, most likely, kind of an inference, is that they needed the title to convince somebody that was going to put down $12,000 in cash, that they had, the ability to deliver title to the truck. And, that's probably the context in which it was used. I'm sure the title, but there's a reasonable inference that the title documentation was probably, filled out. But, obviously part of what a dealership does is send this stuff to the state. And this guy wasn't interested in, any formalities being completed or anything like that. He just wanted the money. And it really goes to show that the sale here was completed for the benefit of, Mr. Nasser and Exotic Motor Cars, not for, and the fact that it was that they're, a fraud and this, that, and the other thing. I mean, I think the fact that they went to the trouble to obtain the original title is evidence that it was needed, in the completion of this fraud. And like I said, there's no reason to believe that there was any bank, because that's not the way this transaction was completed. So I think that there's a lot of facts here that are very, difficult to discern. And a lot of the problem is that at the time that discovery was being taken in this case, and obviously COVID interfered, the police were refusing to provide police reports and less and such because of the, the criminal investigation was still fresh. And it's even in the record that they couldn't provide an unredacted police report, but, because of the ongoing investigation. I suspect that will abate over time, as this case becomes, as the investigation concludes. That's really about it, unless there were any questions.
All right. Good timing. Thank you both. Well argued. We'll proceed to the third case, which
Thank
is
you, Your Honor.
Ivy Chase Apartment versus Ivy Chase.